So let me read out loud a few quotes. Please don't be scared. The end of insolvency law as we know it, undermining the very foundations of private law. It is much better not to have any directive at all than one with such a rule. There was a letter written by Douglas Byrd accusing European legislators of not having understood his concept of relative priority rule. There were letters warning of a disaster sent directly to several well-identified members of the European Parliament 3 days before the vote took place to try to make them change their mind about the directive. Of course, the people who were sent the letters were specifically targeted because in the past they had been opposed to the directive for completely different reasons, but they were very much targeted for it. I got a call from Insol Europe saying, we've just been asked to write a document trying to oppose the directive because there is a new relative priority rule as an option included in the directive. All of these happened a few days before the vote in the European Parliament, after years of work from the Commission and other European institutions, with a huge attack from air, land, and sea to derail the European directive because of this. Was that right? Should we all quickly leave this room, pick up our children from school, and seek for shelter somewhere, at least those of us who live in Europe? To discuss and answer that question, we have an extraordinary panel here today. First of all, we have Michaela Carpus-Carthea from the European Commission, and the main person responsible for the directive, not perhaps for this rule, but certainly for the directive. So, and a new, hope and very, very gladly, a new member of the III just joined us this year. She's going to give us an overview of the directive and more precisely of the absolute relative priority rules and best interest tests perhaps as well. Then we will get a different perspective and also hopefully a critical one from Richard Levin, whom you all know, partner at Jenner & Block, one of the most famous insolvency lawyers in the world, and no doubt, as everyone knows, one of the authors of Chapter 11. And when 1978 bankruptcy code, I can't even imagine how young you were when you had those ideas. So
I was 7.
7.
Child prodigy.
And next to him, we have Riz Mokal, Professor Riz Mokal, now at South Square as a barrister. Probably the youngest legal theory professor in UCL in decades, if not hundreds of years. He made his chair when he was 34, I think. He's extremely young because he's only 2 weeks younger than me. And he was involved in a European research project which informed the making of the directive and which had some influence allegedly in the final introduction of a relative priority rule. Lorenzo Stanghellini, who was going to be speaking in this panel but for personal reasons could not make it, and a huge hug goes out from here to him, was also part of that project. Christoph Paulus, who's also here, myself were the people running that project. But Riz is going to step in the shoes of Lorenzo and talk about directive and the justification for the relative priority rule, and also give us some insights concerning the schemes of arrangement. And we also lost, this all happened 3 days before the conference, we also lost another panelist, Dominic Emmett from Australia, who had an urgent case and couldn't fly to Barcelona. So you look at me and say someone had to deal with 2 casualties 3 days before the conference. So, but in any case, I'm sure we're going to have a fun panel, and we're going to enjoy it a lot. We will then, they'll have some time to speak, and then I'm sure we have some good time for discussion from the floor, which I'm sure will trigger some interest. Richard.
Thank you, Ignacio. Thank you for including me on this panel. do we have slides? Do I need to?
Yeah.
There we go. So I've been asked to talk about the American experience with absolute priority and relative priority, as perhaps informing a little bit the way the European Commission or others might think about the death of civilization as we know it from the adoption of the relative priority rule. On this point, as Justice Holmes said many years ago, a page of history is worth a volume of logic. So when I discuss the American experience and our perspective on it, really what I'm going to do is I'm going to tell you how we got from there to here. So let's start with there, which was former Chapter 10, Roman numeral. We called it Chapter X sometimes just to distinguish. We'll see as Chapter 11, which was XI. It was designed for large, usually public companies. It could affect all debt and equity, the entire capital structure. This was adopted in 1938 after the Great Depression, toward the end of the Great Depression. And it was a comprehensive restructuring scheme that had grown out of the equity receivership practice that had developed in the United States in the late 19th and early 20th century, and now it was made statutory in 1938. So as I said, a comprehensive restructuring. There was a strict application of the absolute priority rule, which required a mandatory evaluation, as Mihaela said. That could be a problem. It was expensive, time-consuming, and very contentious. It was a cumbersome process. Former Chapter 11 of the Bankruptcy Act, as I said, we called it XI. We now call it XI to distinguish it. It was designed for the smaller businesses, the SMEs of today, what we would call an SME. Chapter 11 could not affect secured debt, and it could not affect shareholders without unanimous consent of each of those classes. So it was strictly a composition procedure for unsecured debt, and it was enacted at a time when unsecured debt was relatively common in a capital structure, both unsecured loans and unsecured trade debt. We see, although today there's a lot more, there's plenty of unsecured trade debt, there's very little in the way of unsecured loans by comparison to 40 years ago when Chapter 11 was enacted. And because the Chapter XI could affect only unsecured debt, there was no need for or application of an absolute priority rule. Only what was referred to in the statute is this, and this is where the phrase best interest test comes from. Chapter XI actually said the court may confirm the plan only if the plan is in the best interest of creditors, and the courts had interpreted that phrase, best interest of creditors, to mean that the plan treats them better than a liquidation would. And so when we drafted current Chapter 11, we actually spelled that out. Instead of using the term best interest, we wrote the plan has to return for each class more than they would receive in a liquidation. And Chapter XI was a fast, relatively inexpensive procedure. In fact, so much so that by the 1970s, major corporations, there weren't many major corporations that had a lot of debt and needed restructuring, but those that did, major corporations were using XI, even though it had been originally designed for smaller businesses. And in Chapter XI cases, the most common practice was not for the secured creditor to demand everything and to take his or her marbles and go home, as it were, but rather there was some value to the secured lender to cooperate in the reorganization because the collateral would be worth more as part of the going concern than it would be if the secured creditor foreclosed. So even though XI did not permit forced modification of secured debt, in most Chapter XI cases, there was modification and it was with consent. The financial markets, economic markets in the United States in 1978, the distressed market was largely undeveloped. We didn't see the enormous growth in the use of the bankruptcy code for large companies until the 1980s when, with the growth of debt and leverage finance and below investment grade bonds and debt. So it was a relatively undeveloped market. And there was certainly no market for distressed business sales. It was just unthinkable that somebody would buy a business as a going concern out of a reorganization. In fact, that was the need for reorganization. You had to keep the business going because otherwise it would be broken up and sold for scrap. And there was no claims trading. Creditors were, as I have said many times, chained to the negotiating table, and that gave them an incentive to stay at the table and get a deal done. And that was the market against which Chapter 11 was enacted. In 1978, we thought it made no sense to maintain the two separate chapters. There was a lot of artificiality as to which chapter would apply in any given case, which one was selected. And so the effort was to try to combine the two separate procedures. And the question that we had to answer was, in the difference in value between a going concern and the liquidated company, there's a going concern surplus, and who is entitled to that surplus? And we concluded, and I still believe today, 40-some years later, there is no correct answer to that question of who gets the going concern surplus. Everybody contributes to that going concern surplus in some manner, and so the best way to address it was to let the parties negotiate a division of the going concern surplus with the threat that if they didn't reach a conclusion, the going concern surplus would disappear because the company would liquidate. And that was, but there was a backstop put in, and that was the absolute priority rule that we now see in Section 1129B that said, if most of the parties can work it out, but there's one or maybe two holdout classes, then the plan may be confirmed despite their non-acceptance of the plan if a slightly modified version of the absolute priority rule applies. Part of the threat, at the time at least, was that everybody understood that Chapter 10 process was expensive, time-consuming, and could itself destroy value by the delay in the reorganization. And one of the two incentives for the parties to go along, one was that liquidation was a much worse alternative, and the other was that the threat of evaluation and an absolute priority hearing created uncertainty and delay and cost, and that was another incentive for them to try to make a deal. So that's where we developed how the concepts for Chapter 11 came along. Now, 40 years later, there's an active claims trading market, and creditors no longer need the long-term business relationships that they had and wanted to preserve in getting a deal done in Chapter 11. These are professional creditors who assert their rights, and they're claims buyers who are very often actually looking to buy the business through converting their debt to equity. Now we see a very common whole business security interest, which was not at all the case in 1978, and there's a very active market for buying a distressed business as a going concern. And this is, Chapter 11 has migrated to large professionally managed firms, not the SMEs for which it was originally designed. That's what the market for reorganization was in the 1970s. Although people now look at Chapter 11 and say, well, this was just written for the major public corporations, the fact is it was exactly the opposite. It was written for the small businesses, and the major corporations that have gotten into financial trouble as leverage increased through the 80s and 90s have migrated to use it, and it's become an effective tool for that. And then the other part of the market 40 years later is our culture, always litigious to begin with, has become even more so. And the result of all these market changes is that the senior creditors now demand APR, and that's why I think many would think that the world will end if we do not have APR, that lending will cease, or that interest rates will go through the ceiling, and that will destroy the economy. It's interesting now for me to hear that creditors think that the bankruptcy code is so important in determining how our economy performs. We would have never thought of that 40 years ago. But the result is that the valuations are risky and uncertain and expensive and delaying. Although they're quicker than they were 40 years ago, everything moves faster. And the result now is that instead of negotiating a resolution or a division of the going concern surplus, seniors just give a tip to settle the valuation disputes, and I'll call that a negotiated relative priority rule. And that's how we got there. Conclusions, the market is much more powerful than the law. As I said just a moment ago, bankruptcy law provisions now, perhaps less so in the 1970s, really do affect credit availability. But considering what happened in 2008, my question is some indirect, that is non-regulatory, market limit on credit a bad idea? If we make the bankruptcy laws a little less friendly to senior lenders who believe that they can always collect as long as they have collateral, is that such a bad thing if credit were restricted just a little bit?
Very good.
Thank you, Richard. So, for our negative oracles from the Netherlands and Germany, so now it seems like maybe in the US there is not such a strict absolute priority rule after all, not even there. Riz?
Thank you, Ignacio. I would draw your attention to this one of Richard's slides, the market in the US as he describes it very helpfully. In considering the European debate, I would ask you to think about the European economies with which you are familiar and ask to what extent that description fits those economies in the EU. And that would provide, I think, a very important context in which you consider the lessons to be learned from the US experience. So I'm going to,
No, skip that. Yeah, that was, yeah, there you go.
Okay, so I'm going to take a couple of minutes to describe the position in the US and in the UK. I'm not interested in getting the doctrine right in relation to either of the two jurisdictions. Over the last few days, I've spoken with 6 distinguished US judges, academics, and practitioners in relation to the operation of the absolute priority rule. And you won't be surprised to learn that I've received 8.5 views as to how the APR works in the US. I can tell you that I would not deign to describe the UK system, given that we have some of the most distinguished judges and practitioners from the UK who have played a critical role the last 2 decades in developing the scheme jurisdiction. So I'm not going to claim any deadly accuracy in relation to the description of the UK system, which is my system. All I want to do is to convince you that the APR is not an accurate description of either system. So as long as you are with me at least some of the way in that conclusion, my job is done. So APR is spoken about, worshipped, is used as a shibboleth in the textbooks. But you wouldn't be surprised to learn that the textbooks are not necessarily accurate descriptions of reality. Take the US system first of all. And I take Steve Lubin's quote here from a 2015 paper, not because Steve is the only person who's making this point, but because he makes it with due provocation. And I like that. As you will see, it says, there is no absolute priority rule of the kind described in the textbooks if you examine US practice. And if there were, it would have to be got rid of because it would be deadly to any prospect of restructuring. So why does this sensible, if provocative, scholar, who is regarded as doing serious work, why would he say something so counterintuitive? Well, as I said, I would ask you to think about the APR like you should think about the principle, the para passu principle, the par conditio creditorum rule. It is a shibboleth, but it structures analysis, not practice. The so-called exceptions swallow the so-called rule. Take the example of US practice. Jevic, the Supreme Court's decision, many of you will be familiar with it. In relation to Jevic alone, I've received absolutely contradictory opinions about what the Supreme Court held from distinguished practicing US lawyers and from judges. So I'm not presenting a consensus view. I read the opinion, And I'm giving you the relevant bits from that opinion. The Supreme Court says that APR only seems to apply to the court's final determination in relation to the commenced Chapter 11 process. It applies to confirmation of a plan, or it applies to conversion to Chapter 7, and Chapter 7 has a very strict regard for the absolute priority rule. And it also applies, and this was the point in Jevik, to structured dismissals, where the court is seeking to restore the status quo ante as it was just prior to confirmation. But the court explicitly confirms that the APR does not prohibit, quote, interim distributions that violate ordinary priority rules, but, and here's the relevant bit, which serve significant code-related objectives. And what are these objectives? In particular, successful reorganization and making even disfavored creditors better off. It is not clear to me, reading the majority opinion, whether these are supposed to be disjunctive requirements or whether they are supposed to be present together in order to justify departures from APR. So what does the court have in mind? Well, here are some of the important elements of practice which require departures from or disregard of the absolute priority rule. Assumptions of contract require cure of breaches as at the time that the contract is assumed, which entails payment of the counterparty on the contract, and compared to like creditors, contractual counterparties, but whose contracts are not assumed, the parties whose contracts are assumed receive full payment and are better off. They're not subject to the APR. First day motions, wage orders, critical vendor contracts, roll-up to permit lenders to be paid on pre-petition claims. Certain customers are paid in the ordinary course of business, pre-petition warranties as in the automobile bankruptcies, and settlements in ongoing litigation.
Riz, if I can interrupt you for just 1 second on that, a historical point again. None of those things existed in 1978, and those practices came into being only starting in the late 1980s and 1990s. So it was much more of an absolute priority system 40 years ago.
Thanks, Richard. So practice develops and accrues around the statutory text, and the statutory text is supposed to structure the practice. It's not supposed to be some sacred scriptural rule which must be adhered to or else, or the gods of insolvency will rain hellfire upon you. Now turn to the UK, which does not, in relation to the scheme jurisdiction, I think many of us would say that the scheme jurisdiction, together with Chapter 11, is one of the most successful restructuring processes in the world. The scheme process does not even pretend to have any explicit APR protection requirement. Court confirms compliance with statutory provisions, considers whether classes are fairly represented, and tests whether scheme is one that a class member may reasonably approve. That is the court exercising its independent judgment. Class composition is not defined in the very thin statutory text in the company's law, which we've had since the Victorian era, since effectively the creation of companies in the late 1860s and 1870s. And the test is that creditors and other stakeholders whose rights are not so dissimilar that common interest consultation would be impossible. So this is, some have described this as question begging, others that it is empty. In fact, it is profoundly powerful, and it focuses on the substance of the rights, not the interests that creditors hold. And it gives sensible judges the opportunity to ensure that creditors are not classified separately and therefore given a veto on a successful scheme. The last bullet point on the slide is the T corporation principle, and that has also led to the T corporation scheme, where you transfer assets and novate some of the liabilities to a new company, leaving remaining claimants to claim against the old co-shell. And one of the ways in which the old co-shell may be treated would be by being put into liquidation, and the insolvency office holder, the liquidator, would ask whether the transfer to new co of the assets of old co was, for example, at an undervalue. So it would be those sorts of tests which would be in the background to the scheme. So far I've sought to show you that neither of the most successful restructuring processes, including the one which is the origin, the cradle of the APR, in fact adhere to the APR in practice. They, at best, apply APR to the rump estate, which is left when all of the other little bites have been taken from it. And as I said, that is very closely analogous to the pari passu principle, which is subject to all these so-called exceptions. So what is restructuring's guiding principle? Well, I think I could say the restructuring principle is don't be a fanatic, where a fanatic is somebody who prioritizes one value to such a great extent that he or she allows it to annihilate all other values. And those who worship at the altar of APR are fanatics because they do the first of those sub-bullet points. They seek to respect pre-existing rights. And that is profoundly important. Respect for pre-existing rights is not simply important for this particular debtor, as we all know, and as those of us who are academics teach our students, it is also important from the ex-ante point of view in creating incentives for the future. So respect for pre-existing rights, profoundly important. It is not, however, all important. It should not be our religion because it has to be balanced against the incentivizing of value preserving or value maximizing restructuring by rewarding claimants whose contribution a restructuring requires. And if you go back to the so-called exceptions to which I drew attention in US practice, assumption of contracts, first day motions, and so on, each of those can be conceptualized at a very high level of generality as recognizing those counterparties that the debtor company requires to keep on board in order to have a chance of a successful rescue, of a turnaround, or perhaps of a going concern sale. New directive, I think drafting is not ideal, but it is, as Michaela rightly said, a profound leap forward for the EU jurisdictions, many of whom, as she explained, do not have familiarity even with the basics of restructuring practice. So it is a huge improvement in my view, and it was a profoundly imprudent step to seek to sink the implementation of the directive as some of our distinguished academic colleagues sought to do. But remember that the absence of harmonization is not a bug. It is supposed to be that way. The directive itself provides, as a feature rather than a bug, significant room for experimentation. And that is how it should be. The EU 28 jurisdictions are at different levels of economic development. They have different legal systems. They have different social and judicial cultures. It would be horrendously wrong-headed to seek at this point to impose a uniform insolvency law, which, as we all know, plugs into significant policy, social, even religious, cultural objectives. So seeking to harmonize all in one go would be disastrous, and that's not what the directive seeks to do. I want to draw attention to the new best interest test, which is frequently missed. The traditional understanding of the best interest test is returns and liquidation. That is to say, dissenting creditors should receive at least as much as they would in liquidation. However, I'm glad to say at our recommendation, we were, to my knowledge, the only group to recommend that there should be a departure from the returns and liquidation best interest, understanding of the best interest test to returns in the realistic alternative to proposed restructuring. That is the realistic or real alternative returns. And this is important, and it has fine heritage going back in English case law to that Court of Appeal decision in 1893, where the Court of Appeal refers to testing whether to approve a scheme of arrangement by asking what the creditors would receive in the alternative. And it's also supported by US practice. I owe this point to a long seminar with Professor Ted Janger yesterday over breakfast. That is, US courts would ask, if presented, to make a comparison with an alternative plan, not liquidation, but an alternative plan, or with terms realistically offered by another buyer. I should have underlined realistically there. The US bankruptcy judges, and I'll be corrected, I'm sure, there are distinguished representatives in the room, would not be taken in by alleged offers, which I understand are to a penny. Why should the real alternative, real best interest, returns and the real alternative interpretation's best interest test matter? It's because the alternative, which is to give dissentients only as much as they would receive in liquidation, may be profoundly expropriative. It would be expropriative in situations where the restructuring process is begun opportunistically, and the alternative to the restructuring is not a liquidation. Perhaps it's a continuation of the business. Perhaps it is some other way of going forward. And what is sought to be done is to say to creditors who are sought to be frozen out that they should receive as much as they would in a liquidation, ex hypothesi, not on the horizon, and be done with it. So that's the problem. The new best interest test does better. I want to go to the relative priority rule because I'm running out of time.
Very quick, yeah.
This is the statement. If you boil it down, at least as favorably as any other class of the same rank and more favorably than any more junior class. Again, very thin. It is not the absence of a structure, but it is a very thin structure requiring careful implementation. I would draw attention to the red text at the very bottom of this slide, which provides, again, the text from Article 11 of the directive. Member states are allowed to derogate from the specific rules provided where the derogations are necessary in order to achieve the aims of the restructuring plan, and where the restructuring plan does not unfairly prejudice the rights or interests of any affected parties. I would draw attention to my discussion of the Jevic decision and the so-called exceptions to the APR, the iridium exceptions as discussed by the Supreme Court. This last bit of the directive seems to create room exactly for that. So I owe different types of priorities, the analysis of that, to Jacobi and Janger's 2018 paper. We can perhaps come back to that, but in relation to asset-based priorities and structural priorities, which are described on this slide, it's not unfair and not imprudent to say that the minimum, the floor for these types of claimants should be set by the best interests in the realistic alternative sense. Waterfall priority, which is priority resulting from the provisions of the law, is somewhat different. So this is the point I just made. So how should relative priority in the directive be distinguished? Quicker than that, the bare relative priority would simply be to say, take the words of the directive and just leave it there, which is to say, requires senior dissenting classes to get a higher proportion of their claim than the dissenting classes. Senior should get X percent, if mezzanine will get Y percent, and junior Z percent, and X is greater than both Y and Z. So that's just the literal implementation. It's maximally flexible because the entire restructuring surplus is up for grabs. It is also problematic because it is the most uncertain, and certainty would be one of the values that you aim for. The second alternative, and I'm one slide away from finishing, is the returns in liquidation. That provides the comparison. So compare the dissenting class with the class below in liquidation. And that fixes the returns and liquidation, fix the relative treatment of these two classes. So for example, if the dissenting class would receive 80% and the class below 40% in liquidation, then the ratio 2 to 1 is the relative priority that the dissenting class should receive in comparison to the class below. And the third and final interpretation that I'm providing, there are going to be many others, is to focus not on returns and liquidation and the comparison, the proportions in liquidation, but on the realistic alternative, but do the same thing all over again. I've mentioned, equity is very important. On the interpretations, each of the interpretations that I've mentioned where equity is underwater and the plan proposes to cram down the junior most creditor class, equity cannot receive or retain anything under the plan in the, as an implication of exactly the principles that I mentioned, the interpretations. So in some cases, there would be SME restructurings under the RPR on a carefully implemented version of the RPR, which would not have been possible under the APR. That serves, in our view, one of the objectives of the directive. Thank you.
Thank you. Okay, so we've allocated plenty of time for debates. Unless there are any quick reactions from the co-panelists.
There are no quick reactions. There are some reactions, but they are certainly not quick. So let's go to questions.
All right. So since I just learned today that Article 11, which we destroyed, was influenced directly by Adrian Terry, I think it's fair only to give him the floor to make some comments, perhaps, at what we did. Adrian, would you like to? May I ask you to stand so everyone is...
Many thanks. First of all, congratulations to the panel. I think it's been brilliant and it has very well exposed what is the situation, what the situation is and the different approaches from Europe and the US. I would like to thank Michaela for the personal reference. Actually, that is not true. I mean, the proposal of a directive was the work of the group of experts as a whole. It was a collective work. And it was headed by Michaela, and actually, if there was a specific and differentiating a contribution, that was yours, Michaela. So thanks for the reference, but actually, it is the other way around. And,
everybody's denying responsibility here.
No. I think the main advantage of the directive is the fact that it introduces cross-class cram-down. I think that only having cross-class cram-down introduced through the directive and the fact of being able to affect shareholders is a gigantic leap forward, because it forces the legislators to really reflect on how a restructuring shall encompass all the capital structure, and not to allow that the shareholders have veto rights, which is one of the main problems right now in restructurings in Europe. The slight problem that we have in Europe right now is this debate between absolute priority rule and relative priority rule. I am quite skeptical about relative priority rule. I find commendable the purpose that relative priority rule tries to address, which is to allow shareholders or junior creditors in certain circumstances to maintain some claim or interest. But I believe that the best way to achieve that purpose is probably not through a relative priority rule, because the relative priority rule is not the best shadow under which to negotiate a plan. I believe that if you want to reach a consensual plan, the shadow under which you have to negotiate it is the absolute priority rule, and only then will you achieve probably a consensual plan. If the shadow under which you negotiate the plan is a relative priority rule, that gives an incentive to the junior creditors to hold out and to wait until the judicial determination on what is the construction by the judge of the relative priority rule. And I think that doesn't lead to consensual plans, but on the contrary, to more litigation and protracted negotiations that do not lead anywhere. In any case, I think that the debate is fruitful. It's a debate that shall be had in Europe. In relation with Richard's approach, I think it is it makes sense to debate whether secured creditors shall share some of the value with the rest of the estate. But I think the best approach to take in that respect is in the way that Bebchuk proposed, so as to have partial, not relative, but partial preferences, so that we could maintain the absolute priority rule applicable to different classes and simply allow for prescribed parts of the security to be shared with the estate, but not to affect the overall comprehension of the cross-class come down by taking away its main safeguard, which is the absolute priority rule as a cornerstone. Thanks.
Thank you, Adrian. This is very good. Yeah, please, go on.
So, thank you for your comments. I think your comments show that you do not view, as many critics have viewed, the absolute priority rule as a religion, but rather as an important leverage to create negotiations and to create a deal. But I disagree with you that the absolute priority rule is the only way. What I believe, I think it drove us in the 70s, and it's still currently true, what drives negotiation is risk and uncertainty. And the relative priority rule, as it's described in Article 11, creates big risk for the junior creditors. It creates uncertainty for both sides, and that, I think, negotiating in the shadow of that is going to be helpful toward driving deals. You don't need, even the absolute priority rule, as Riz has said, in practice is not so absolute, because if the valuation is high, you're going to wind up with a very different result than if the valuation is low. So the secured creditors cannot completely rely on the absolute priority rule as some kind of protection that gives a threat to the juniors, because the juniors have a threat of showing a high valuation that might get them some recovery. So I think this accomplishes the same objective as the U.S. system does, and I hope at least will drive deals, because that's the better way to go, always.
Richard has made the point more beautifully than I would have done. I would just say your question implies the negation of my account of US practice, because you are basically saying, no, what you have read in the textbook is the correct way in which negotiations are structured in the US. But what I'm suggesting to you, and you may just disagree, and that's fine, but what I'm suggesting to you is, in fact, properly advised parties will not take it to be the case that the APR is in the background, particularly where pre-commencement negotiations take place. Properly advised parties will know that there are alternatives, including some of those that I've mentioned to you. And so safe harbors I did not mention. Some parties' misuse of financial contract safe harbors is a big issue for a certain type of lender. So what we are talking about is at cross purposes, not about concept so much as empirical description of US practice. You take it to be the case that the APR accurately describes US practice, and you reason from that. I just say that's wrong.
Professor Stefan Madaus. Didn't you ask for the floor? I thought so, right? Okay, no? Didn't you ask for the floor? Sorry, I thought so. No. So Ted Younger, John Poto come after that.
That's
right.
lovely. Thank you very much. Thank you for a very enlightening presentation. I wanted to highlight one thing, and that is probably what I experience when I try to explain the relative priority rule to my German colleagues and in most of the German or even European level discussions, which is the basic feeling that the relative priority rule, as you read it now in Article 11, and we've shortly had it on there, it's very complex, very not easy to read article. And many think that relative priority rule is, once it's implemented, still it's something very sketchy, something not like a clearly structured background to a negotiation. I'm pretty sure it's not going to be like that. This is the directive. It leaves a lot of room, more favorable. So you can do a lot at the implementation stage. Once it's implemented, it might still look like this for certain jurisdictions who trust the judges to develop a far more structured background for negotiations. But from the discussions, at least with the German Ministry of Justice, I know that they're going to implement something which is much more specific. So I think the view to favorably argue in favor of absolute priority rule based on the idea that it's a much more clearer background for negotiations is understandable at this stage, but it might not be the key argument anymore once it's implemented. And when we come back to the advantages of it at the negotiation table, once this is out of the way, I find it rather easy to convince banks, financial creditors, everyone who you would assume to be in the senior groups, to get a feeling that this could actually make things easier. As you said, we have a clearer picture of the reality of things are, so it could make it easier to come up with a deal. This is just a prognosis. I'm not sure that it's the case, but I hope this will be a learning curve as well here in Europe as it has been for us. Thank you.
Thank you, Tajanga. Please, not too long. Yes.
So
Ted, just a question, okay? The question.
if asked to explain bankruptcy while standing on one foot, I would say that Riz got it exactly right, quoting Steve Levin, by saying basically the judges are trying to create in a broad way a situation where the decisions they make all creditor classes better off at any point during the case. Actually, but what I want to focus on is the fact that I think absolute priority in the U.S., and the rest is commentary, but a little bit of commentary. Absolute priority in the U.S. does not mean what most people think it means. And what I want to ask Rich to do, so I give you back my time, is to explain two different Phillips on the absolute priority rule. First of all, what is the fair and equitable standard for a secured creditor, which is to say an asset-based claim on the top, which is how senior can you be? And then the second is, could you explain the new value corollary to the absolute priority rule, which is to say the limits on the ability to subordinate a junior? And I'm going to suggest that once, I don't know what he's going to say, but once he has explained them, there will not be that much air between what the U.S. statute describes as the cram-down standard and what you would be empowering under the EU directive as relative priority. I think the words are giving a lot of, creating a lot of noise between what people are talking about and what they aren't. Short enough?
Yeah.
Okay. Very good, thanks. Richard.
Also while standing on one foot. Secured credit, under the U.S., under the bankruptcy code itself, the U.S. law, secured creditors are not included in the absolute priority rule. They are treated separately. And the rule for secured creditors in a cross-class cram-down is that the secured creditor receive the value of its collateral. The statute doesn't say whether that's going concern value or liquidation value, and that's, again, another uncertainty that's baked into the statute. Although the Supreme Court has suggested it should probably at the reorganization stage should be the going concern value, and that, as Riz phrases it, the absolute priority rule applies only to the rump estate, what is available for the unsecured, the juniors, and the equity. So, all right, they take them off the table. The world has changed since 1978. That system that I just described made sense back then, but now when secured creditor takes security interest in all of the assets of the business, that idea that the secured is outside the absolute priority rule is much more difficult and has been implemented by saying that the secured gets whatever value value of the business up to the amount of the claim, and then the balance of the value in the business can be distributed among the other classes. And the new value exception, the new value corollary, is that if a junior creditor puts in new value, the junior creditor may share in the reorganization value in an amount equal or approximately equal, you can never be precise, to the new value put in. The Supreme Court, in interpreting that, has said two things of great importance as it applies in the European directive. Number one, sweat equity is not new value. That's a U.S. rule. It doesn't necessarily apply here. But it was a driver in combining chapters 10 and 11 because for SMEs at the time, it was mainly sweat equity that the old equity was putting in, that is, staying with the business and trying to make it succeed after the reorganization. And the second aspect is that the value that the new credit, that the old junior creditors or equity is putting in has to be market tested. In other words, they can't take over the value, take over the business, claiming that the value of the enterprise is what they say it is without some market test to determine, which of course then affects the how far the waterfall goes down. Tried to do that quickly, probably a little bit vague as I did, but.
So Rito, is it now in the US also similar to have an all-around security right over the business, like a floating charge in the UK?
Completely, yeah, especially in the larger businesses, but even in the smaller and medium businesses. Well, in the very small businesses, you don't see it so much, but in the medium to large-sized businesses, it's very common to have a pervasive security interest in all assets.
Okay. John Paul, no, sorry, Federica.
I have a very straightforward question for Michaela. I'm very curious to know if in the debate was addressed what is my main concern personally in relation to the relative priority rule and is the effect on the financing. Like financing is crucial for the economy, for the restructuring. I'm sure that it's clear to everybody that the relative priority rule will bring some uncertainty. And in particular for asset-based lenders, alternative lenders, I would really love to know more about how this concern has been addressed and discussed in the debate.
Well, I was about to say, listening to Reese, that you know, we have some other provisions in this directive which would probably further modulate how the absolute priority rule would work if a member state would implement that solution. And the rules on protecting new finance and interim finance is one of those rules. So already in that article, we give member states a lot of freedom to define what exactly is interim financing and to give it appropriate protection. And that might be one way also of softening a bit the APR when implemented in practice, obviously. So it is, I agree with you, it is an analytical tool, and in practice you will have lots of other provisions which would interfere with the strict application of that tool. But it's true that our main objective as the Commission, our red line in negotiations, was to have this cross-class cram-down mechanism. I'm super happy that you also mispronounce it because...
In the U.S., we don't call it cross-class, it's just cram-down because the minority, binding the minority and the dissenting minority in a consenting class is, we don't refer to it as cram-down at all. So we never use the phrase cross-class. Not so much.
Yes, so that was our absolute red line, and the other red line was we need to offer dissenting classes an additional protection than what we offer dissenting creditors in one single class. That's why, because we also had that idea, okay, why not use best interest, and that's it. We don't need an absolute priority rule. Of course, best interest in the new... Real alternative. Exactly, yes. So the second possibility. But we thought that absolutely gives the wrong signal. And we need a bit more protection for entire classes when we disregard basically their opinion on a plan, be they in the money or not. As I said, in many European jurisdictions, that's simply not an issue. You know, you have a claim, and there's a right to property attached to that. So you know, there are many people who attach a lot of importance to principles above economic realities when you come to a real restructuring or a liquidation. We did not discuss a lot on financing when we discussed the relative priority rule. I mean, everybody is familiar with Bismarck's sentence that you shouldn't look into how laws and sausages are made. So what happened was that we talked a lot about our proposal, about the absolute priority rule, and we've heard lots of criticisms from member states. We realized we're not going to achieve not a consensus, but we will not even achieve a majority. And we've tried, before embracing the relative priority rule, we've tried to build in the absolute priority rule some derogations. So what you have mentioned at the end there, so member states can still derogate from the absolute priority rule if it's in the interest of restructuring. That was one sweetener we've put in there. It was not sufficient, basically, for many member states. And when we had the conference in June, if I'm not mistaken, July.
Yeah.
Exactly. So in July we had the conference. We've disseminated the information about that paper to member states. August, nothing happens in process. And in September we had the rule on the table, and it just went, you know. So there was no objection to it, and unfortunately no discussion. And for some member states that was a big problem. Not when they agreed to this in October last year, but when the Parliament came in December with a complete redraft, and they were complaining, we have been discussing this for 2 years, agreed on something which is perfect in our opinion, and now the Parliament, you know, completely changes it. And what we have tried to do between October and December was basically to mitigate the harm which this reshifting of the provision proposed by Parliament. Sorry, I hope there's nobody from the Parliament here. Yeah, one of the things they wanted to introduce, and this has nothing to do with the absolute priority rule, perhaps, but they wanted to impose a rule that you need a majority of classes.
Head count, yeah.
Yeah, the head count as an obligation for all member states, in addition to the majority in value, but also when it comes to the cross-class cram-down, majority in the classes. And for us, that was a no-go because we know where the situation is. Most member states will implement this directive by having only 2 classes of creditors. As I said, many don't even have the concept of classes of creditors, but when they will implement it, most likely they will say, you need 2 classes because that's the minimum the directive requires. Secured creditors and unsecured creditors. And if you ask a majority of classes in 2, you basically have unanimity. So you basically undermine the whole cross-class cram-down. So that was something we the Commission, could not accept. So
Right.
What you see now, it's a sort of compromise to still achieve our objectives while giving the Parliament the confidence that when there is a majority of classes supporting the plan, then that plan can be very quickly confirmed by a court. So.
Okay. Last question, John Potter.
Thank you very much. This panel was fascinating. Riz is conducting me. Thank you very much. This panel has been fascinating. Riz, you've now convinced me that the American system, with its purported absolute priority, with all its jurisprudential carve-outs, has maybe drifted towards a relative priority scheme. And so the takeaway I have from that is that we shouldn't waste our time debating about the superiority of absolute versus relative priority, because the market will just synthetically gravitate towards whichever is superior. And as for the idea of if we have to select an absolute versus relative priority rule, if I had a first best analytical belief that one would reduce the cost of credit, create financing more available, then I would normatively prefer that. I share Rich's intuition that that's a fool's errand, that anything you can tell me that will reduce the cost of secured credit, I will say will raise the cost of unsecured credit. And so if I don't have a strong belief that one of those will help a normative first principle, then I'll go to a second principle, which I do have some perceptions on, and that would be a crass political economy story, which is whatever the differences between absolute and relative priority, I will say absolute priority accords more negotiating endowment bargaining chip power to the secured senior most creditor and relative empowers the junior. So if I have an empirical prior about which of those tend to distort the negotiating process more or which has too much power already, I would select the rule that undercuts or mitigates against that imperfection. And that is a socio-legal, politically contingent fact, I'm just going to say that's a word, which may depend on the context and the era of bankruptcy we're in. 20, 40 years ago, we might have said secured creditors generally participate this much. Now we might have a different perception of how they participate and how the scheme works. So this is a vastly contingent system that depends on just, quite frankly, according negotiating power through the distribution of substantive legal entitlements for a negotiation process.
Thank you.
Just add one,
Not so?
Let me just add one comment as I listen to this debate. I think part of the problem in the debate is that it's definitional, how we define the absolute priority rule. And I think it goes to Riz's point that if we think about it as the whole business, of course, we're nowhere close to an absolute priority rule. But as we thought about it in the US, and the way I still think about it, the concept of absolute priority applies only to the rump estate. 40 years ago, the rump estate had more creditors in it because all those exceptions that you've noted didn't exist 40 years ago. But even then, absolute priority applied only to what was left after the business was restructured. So if you start thinking about it in those terms, it's not quite as unused as you would describe it, but it still has all the problems that Levin notes.
Just final point, I agree once again with what Richard said. In response to John's point, which I go with to a very significant degree, that again is an argument in favor of allowing different European jurisdictions to experiment and respond to their particular circumstances. So this is not an argument in favor of or against harmonization. It's in favor of the right type and level of harmonization and permitting the jurisdictions to respond to real differences which we can't wish away or which we can't by statute abolish.
Okay, thank you very much. Please join me in thanking our panelists.